People v. Butler.
Good afternoon, Your Honors. Cleo Weiss on behalf of DEVON BUTLER. May I please reserve 3 minutes for rebuttal?
Three?
Three.
Yes.
Thank you. My client, Mr. Butler, was made to stand on the side of a road while Apache, the police canine, was directed towards him and put his nose in Mr. Butler's groin to sniff him for evidence of narcotics. This court should hold that that conduct was a search.
Wait, let's just be a little clear. What is it exactly we can reach in this case, given the argument about the LaFontaine issue?
This court can reach the question of whether the canine sniff was a search, and then pursuant to LaFontaine, after addressing whether it is a search, this court should remit to Broome County Court for consideration of the legal standard that would be applicable to such a search and whether that legal standard is met.
Can we reach the issue of the search under the federal constitution, the state constitution, or both?
This court can reach that question under both constitutions because it was preserved under both constitutions. County court's decision cites to decisional law, citing the Fourth Amendment and the New York State Constitution, and the Third Department as well expressly holds under both constitutions that it was a search.
But it seems to me, counsel, county court relied exclusively on federal cases with the exception of one state court case that itself relies on federal cases.
In addressing whether the canine sniff was a search, county court primarily relies on People versus Price, which was a case from this court addressing canine sniffs of luggage. The Price case is quite similar to the United States versus Place case, also a Fourth Amendment case about canine sniffs of luggage. So throughout county court's discussion, in which it's essentially applying the Katz test and saying that there's not a reasonable expectation of privacy in the air surrounding your body, it is repeatedly citing to Price for that proposition.
Price itself cites exclusively federal cases as I read it.
And what I would submit to this court is that if the court finds that county court's decision was only based on the Fourth Amendment, that finding that this conduct, that the canine sniff is a search, is appropriate under the New York State Constitution, but it's also the correct ruling under the Fourth Amendment. And it's the correct ruling under the Fourth Amendment primarily because of the Katz test, which asks first, is there an expectation of privacy that a person has? And two, does society recognize that expectation of privacy as a reasonable one?
Does your argument hinge on the fact that the dog made contact with your client, or would it matter if the dog didn't make contact?
Whether there's contact or not is not a dispositive fact in my argument. I think it's a search when a dog is led into proximity of a person. In this case, whether there's close proximity or contact is not totally clear from the facts. Obviously, if there is contact, under Jardines and Jones, the trespassery theory of the Fourth Amendment would apply. We've got contact.
How close does the dog have to get if you don't need contact?
It's a search when a dog is led towards a person to sniff them for evidence of narcotics.
Well, you have Place as well as Jardines and Jones, and so we kind of know that you can't get, it can't be so far away that it would be the distance roughly that a dog might be able to sniff a person's luggage, right? But you're saying it could be something less than actual contact. So how do you draw that line?
I think that when we ask whether a canine sniff is a search or not, the exact proximity of the canine to the person is not a dispositive fact. And I think that if this court were looking for a distance or a hard line rule about what that would be, I would say it's touching distance. Can you reach out your hand and touch the dog? Could the dog step forward immediately and touch you? So I think that that sort of close proximity, the distance where we might stand talking to a police officer during a traffic stop or talking to another
Why
person.
is that the appropriate standard? The touching proximity standard that you're offering?
I would submit that proximity is not a crucial part of determining whether this is a search under the Katz test. I think we have a reasonable expectation of privacy not to be subjected to canine sniff searches, and that society is prepared to recognize that expectation.
Would that be true if the dog were as far away, for example, as you are from the bench? Is there no role that proximity plays at all, or is it simply that if the canine can detect an odor in the air no matter how far distant, that is a search?
I would submit that if the canine is able to to smell and to be detecting odors emanating from somebody's body, that would be a search.
So could the proximity or the contact affect the standard? That is, make it more clear. Dog, I actually have a dog that likes to do this, but anyway, dog pushes its head up into somebody's groin. That's pretty intrusive, and you might need a higher standard to allow that. But a dog at 20-foot distance maybe is less intrusive?
I agree that when we're looking at what is the legal standard that should apply to such a search, the intrusiveness, the proximity, whether it's a contact sniff, whether it's a close proximity sniff, becomes an important factor when we're looking at the standard, whether it should be probable cause or reasonable expectation.
We can't get to that here.
Agreed. But when we're looking at whether it's a search or not, then the proximity to me is not an important factor in
And
that.
is it dispositive also because of the direction, the dog being pointed in a particular direction?
That's correct. I think one of the important factors in this case that is a finding of fact that county court made and a finding of fact that the appellate division affirms is that Officer Bracco directs Apache towards Mr. Butler. It is an intentional search where the dog is led.
So would it be different if the dog was just in the area and no one directed, but then the dog went towards the person? Is that different?
I agree that an unintentional alert, right? If a police officer is not meaning to conduct a search, is just out with the dog and the dog alerts, that may not constitute a search. And I think the case United States versus Rays addresses unintentional canine alerts, but that's not the case. The case here is a directed search.
What if the officer has the canine out in a public area, for example, a park, and is not directing the dog at any specific individual, but is simply walking around a public space where there are a lot of folks outside and the dog alerts?
In that circumstance, I think we have to look at, is the dog at work? If the officer is taking the dog for a pleasant walk, that's one thing.
Now, let's assume the dog is at work but alerts at, 20 feet away, and the officer was not directing the canine at any particular individual.
That would be an unintentional alert in that circumstance, and I think the example of 20 feet away, that's certainly some distance. I think we'd be in a different circumstance if the officer was, searching for general criminality by taking a dog around to different groups of people in a park and seeing what the dog might or might not get interested in. I think the line between, oops, my dog unintentionally alerted to some people in a park versus taking my dog intentionally into a park to, get close to people is something that would have to be addressed on a case-by-case basis to look at what the officer's true intentions were.
Counsel, I'm sorry. Doesn't Jardine speak of the license that people give when they go out into public places? In other words, sometimes people give off odors of things that can be detected by other humans and probably even better by dogs. And it seems as if Jardine recognizes that fact and accepts that some things, maybe Judge Halligan's example of walking through a park, are acceptable because that's, I guess, not part of your expectation of privacy. We do have to account for that in any holding we make here, wouldn't we?
That what is, I guess, the odors that emanate from somebody's body are essentially in public spaces.
Yeah, I mean, I don't know, you could walk out of your house emanating a strong odor of marijuana that's so strong people can smell it, much less a dog.
And I think that's why looking at the directing a canine to conduct a sniff of a person is important, because that's where we get into the demeaning and humiliating aspect, where it is inappropriate for people or animals to be led to conduct sniffing of people.
So a limitation would have to be that the dog was set in motion to a person,
That's
or at
correct.
least towards a person.
Towards people, or towards a group of people. And I think with Judge Halligan's example, a dog is set in motion towards a park. Let's go sniff people in the park.
With the intent to have actual contact with the human body?
I don't think that the intent to have contact would be important, but the intent to lead a canine towards people to conduct sniffing.
I'm having a little bit of, I'm a little confused why we're going down this rabbit hole. Because in this case, you have contact, correct? Correct?
I think that the testimony is that the canine put his nose in Mr. Butler's groin
So
slash.
there is actual contact. So anything the court might say about actions not involving contact strike me as dicta and not relevant. Or am I missing something in your argument? Do we have to decide that to be able to decide this case?
No, I think to the
So
extent.
would you take that rule? Would you take a contact rule for purposes of this case?
I think that under the Fourth Amendment, a close proximity rule is also appropriate. Yes, under Jardines, if a dog makes contact with a person, that's clearly a Fourth Amendment search, but I think that a broader rule that says directing a canine into the
But what I'm saying is, why would we be deciding that here? This is contact. I mean, it doesn't even raise issues of what the numerous questions you're getting about the type of proximity in terms of the distance, in terms of the intent, in terms of the location. Strikes me that that is more appropriate when we actually have to decide that.
The reason I'm not focusing on the contact here is that county courts' findings of fact and conclusions of law do not say contact. The Third Department's decision affirming county.
So you
court
think this
does
is
say-
related to the LaFontaine question?
I think that the description of this as a contact search is the Third Department's description. I
Yes.
think that's an inference from Detective Bracco's testimony, but it
Yes.
is not county court's findings of fact.
Yeah, but let me just clarify here what's going on in this record and what happened below with respect to the argument. Did not defense counsel argue that it's an unconstitutional search?
Correct.
Yes, okay, all right, so then you have a finding that it's not a search because it's a sniff of the air. And a sniff of the air doesn't have the same level of expectation of privacy and therefore not a search, okay. Isn't that automatically rejecting the contact argument? So why can't we reach it? Why is there some LaFontaine bar to that?
There is not a LaFontaine bar to addressing whether it was a search, which could include addressing whether there was contact. And if there was contact, then it is a search.
So, Judge, let me get one in then. So, Judge Kaneshiro mentioned something that actually fed into the question I was trying to ask a couple minutes ago, and it may be an irrelevant question. It's certainly out of left field. But I assume that there are an awful lot of these drug detection dogs who've been trained to sniff marijuana, and that's now not a crime. And so even in the hypothetical where the officer is walking the dog through a park, the dog may react, dogs may react to something that is no longer illegal. That seems to me to be an undesirably intrusive result. It may be transient because these dogs will at some point be out of service, but what do we do about that now, if anything?
Well, I agree with Your Honor. There is no marijuana in this case, so that's not something that would be addressed in this case. But a dog that alerts to marijuana at this point, I think, is out of commission because would give false positives. So it smells legal marijuana in somebody's car. It alerts that can furnish probable cause for the search of an interior of a vehicle where they find legal marijuana. And so I don't think a canine who's trained to alert to marijuana can be used at this juncture, and on suppression motions.
That's not relevant here, right? I mean,
I think I prefaced my question that way.
It's not this case.
I don't know if you know the answer to this question, but is the contact only when the drugs are recovered? In other words, is the dog trained to make contact only to demonstrate where it is that the drugs are? Do you understand what I'm asking?
I do understand. In this record, there's no description of the canine's training and what it is supposed to do other than it's a passive alert dog that sits. So there's no description of is it supposed to get close or to touch where it detects the drugs in order to indicate to its handler. I think
My question is, right, would there only be contact when a dog has alerted that there are drugs, and then wherever the defendant placed them is where the dog would alert that there are drugs? And I don't know if the alerting is the contact. That's what I'm trying to get at.
the alerting is sitting. So making contact would not be a part of showing where the drugs are. And the example I would give, Your Honor, is where canines are used to circle the exterior of vehicles and to conduct sniff searches that way, it can't make contact with where the drugs are, if the drugs are, say, in a center console or somewhere within the car. So they're still alerting outside of the vehicle to indicate that they sense something within the
I think they can alert to a specific area. They can alert to a passenger car or a compartment or a trunk, if I'm not mistaken.
They can, but where they would be, say, touching a vehicle or indicating on the vehicle might not be necessarily exactly where the drugs would be within the vehicle. I think the canines are trained to get as close as they can to the odor, to pinpoint where it is, and that's why it leads often to contact or extremely close proximity as the canine is investigating where is this odor coming from.
Thank you.
Thank you.
Thank you, Your Honors. May it please the court. Benjamin Holwit on behalf of the people. I would like to start with a point that Your Honor, Judge Rivera made as to county court's decision-making process. As Your Honors are aware, county court ruled that this was a sniff of the air surrounding the defendant. Therefore, I think the relevant question or the relevant fact is that there was no contact. And
Well, the county court concluded that it was a sniff of the air for purposes of coming to a conclusion that it wasn't a search.
correct.
My understanding, correct me if I'm wrong, is that you've sort of conceded the search issue on this appeal, or haven't you?
So as Your Honors may be aware, I am probably the third appellate ADA on this case.
Are you arguing that this isn't a search? Is that your choice?
So I do recognize that I am more or less bound by the brief that we submitted. I would argue, though, that there is a view of the facts, a strong view of the facts, that this wasn't a search.
And it doesn't matter that the groin area is specifically indicated, whether it's actual contact or not?
I think
That's not intrusive?
so contact, sure, there's a level.
With or without contact, a dog pointing their nose ever so close in that particular direction, I'm asking you, you're saying that's not intrusive?
No, I'm conceding that there is a level of intrusion
Okay.
to it, Your Honor.
You're saying it's not a search?
It's not a search because if Your Honors look at the entirety, the totality of what happened, Detective Bracco, went to retrieve Apache. Essentially immediately upon his release from the car, he was pulling towards the defendant and
So police officers, whether they have any reason to believe, they can just get the dog and the dog can just walk around just on an IFCOM and that's fine? Not a search?
No, Your Honor. I think that as county court found and as the third department found, the events leading up to the decision to retrieve Apache, there was reasonable error-founded suspicion on which to do that. The sole, I think, variance happened to be on the point of contact and whether or not that was a search.
So then, given the alleged LaFontaine issue, in your view, what is it that we can reach on this appeal? What can we resolve?
So I think that, as pointed out in our brief, there was, the ultimate issue was whether, and forgive my wording of this, it was whether, the totality of the encounter was proper, which, both county court and the third department went through the various steps of the encounter. Forgive me.
But each marked the encounter differently.
I'm sorry, Your Honor.
Each marked that encounter differently. So again, what legal question can we resolve on this appeal?
So Your Honors can resolve the question of, whether it was a search or not. And I think that Your Honors can reach, the standard, and, if Your Honors determine that it was a search, you can
You know
reach
the
the
answer
standard.
to my question, counsel, whether or not the dog only touches when it detects narcotics? Is that how it alerts?
To be perfectly honest with Your Honor, I don't know. But, on that point, both, not really on that point, but sort of on that point, both county court and the third department characterize it as, a very minimal contact. And I believe my reading of both county court's decision and order and the testimony of Detective Bracco and Detective Haven and the third department's decision, the canine Apache, was in odor and following essentially the scent of contraband, in this case drugs, and the intrusion, whatever level that was, as soon as that happened was when the alert happened. So
What role does an officer directing the animal has, if any?
So in general, I don't actually know the answer to that question. I would disagree with counsel's characterization that in this case, Detective Bracco directed Apache. As I was mentioning earlier, immediately upon retrieval, more or less, of Apache from the car, he was pulling towards the defendant, and Detective Bracco guided him back towards the car, where he started to walk around and put his paws inside the open door of the vehicle. After the
So are you arguing that the canine was acting in a spontaneous manner somehow?
So I do have to concede that Detective Bracco, his testimony was that he thought to himself, well, let's see what is,
He brought Apache over to the defendant, right?
his testimony, Your Honor, I believe it's page A111 or 112 of the record before this court, was that he extended the leash and Apache walked around the defendant and Detective Haven.
Is that a distinction with a difference? He gave the dog the leash, the freedom to go to the defendant.
I don't think it's a distinction without a difference, Your Honor. I think that, giving, a lead, the freedom to roam and follow the scent is different than, pulling and directing, hey, go over here.
But the same testimony says, well, let me see if there's any odor on Mr. Butler. So whether or not he walked the dog over to Mr. Butler or extended the leash so that the dog could go over to Mr. Butler, it seems to me that indicates that he was intending that the dog investigate Mr. Butler, no? He says, let's see if there's any odor on Mr. Butler.
Yeah, that was his, if I'm not mistaken, that was his thought process at the time.
How is it relevant whether he, and maybe I'm misunderstanding you and you don't think it's relevant, but I thought I heard you say there was a difference that mattered with respect to whether the officer walked up to the defendant with the dog or whether the dog was given an additional leash and approached the defendant himself.
Well, I think that there's definitely a difference between simply having a thought and letting
Purposes of
additional
whether it's a
leash
search.
go through and whether he is actively directing the dog. My reading of the testimony from the hearing was more that it was, loosening a grip and letting Apache go where the scent led him. And again, I do want to belabor this point. Apache on his own twice was, in odor, which.
Well, in response to the question, do you use Apache on Mr. Butler, the officer says, I did.
Yes. I don't have, a response to that other than, I don't think there's any testimony to warrant a finding that Apache was directed or led towards. Detective Bracco, gave the freedom to go where the scent led. And I want to stress to your honors that this is, this was a vehicle and traffic stop, and in addition to the numerous exceptions to the warrant requirement, canine searches of the exteriors of a vehicle are, allowable under a reasonable suspicion or founded suspicion standard. And the same justifications for lessening.
So you don't see a LaFontaine issue here?
To be frank, Your Honor, no, I don't.
Yeah. That was not part of the Supreme Court's holding. They just held it wasn't a search. I'm sorry, was it the Supreme Court? Yeah, I think so. That it wasn't a search.
Correct, but it went on to find a reasonable basis for the pursuit based on everything that had occurred during the stop and the interview. And again, I think that the important or the ultimate question is whether the approach of Apache towards the defendant, and the search of the sniff of the vehicle were proper. And I think that both courts determined that it was. They differed in their interpretation of the facts as to why. But I don't think that the third department decided any issue that was not overall decided on by the lower court.
Didn't it decide the standard if it is a search?
The appellate division did for sure,
Yes.
right?
Right, right.
Yes.
And that was not decided by the trial court, right?
That is true. Yes.
So, to me, it sounds like the appellate division affirmed criminal conviction on a ground that, actually a novel ground, that we haven't decided what that standard is, that wasn't reached by the trial court.
But in doing so, it was answering the question of, again, whether the totality of the circumstances of the approach of the entire encounter were proper. And if your honors ultimately decide that, that is not the issue. Obviously we likely, or it goes back to county court, but respectfully, I don't think that that's, the ultimate issue that was handled in either court. And again, respectfully, I think that I didn't even get into the issue of, the ultimate standard, but, I think that ultimately this wasn't a search. If it was, if the appellate division found that properly, I think that, the reasonable suspicion standard based on the cases cited in our brief and the situations cited therein is the proper standard for this specific set of facts. Thank you, Your Honors.
Counsel, I just found some language from the Horton dog sniff case from the Fifth Circuit. And I was looking for it when you were talking about the standard. They say intentional, quoting someone else, they say intentional close proximity sniffing of a person is offensive, whether the sniffer be canine or human. Their language, not mine. Assuming this case allows us to go beyond a touch, would this be an adequate standard, intentional, meaning launched by a human, a law enforcement individual, and close proximity, or would it have to be something even broader than that, do you think?
No, I think an intentional search in proximity, in close proximity, is the standard, and that's the standard that Horton versus Goose Creek, BC versus Plumas, and Tedford versus State from Florida, 3 cases construing the Fourth Amendment, have found that a non-contact sniff search, when it's intentional, is a search under the Fourth Amendment. And with regards to dignity and the sort of humiliating nature of a canine sniff, this court recognized in matter of Patchogue Medford Congress of Teachers that the Fourth Amendment is designed to protect dignity. That is one of the interests with the Fourth Amendment. And just to return briefly to the question of, is this an intentional search? County court's findings of fact, I'm going to quote here, Bracco then brought Apache towards defendant. So with the testimony in this case and county court's findings of fact, it is unquestionable in this case that this is a directed search of Mr. Butler.
So could I ask you, counsel reminded me that there was an automobile stop involved here. So we have People v. DEVON, which I think applies a level 2 DeBoer framework to automobile stops for the purpose of a canine sniff. But subsequently, the U.S. Supreme Court decides Rodriguez and uses what sounds to me like a higher test. But we may not need to get to that here at all, because I think maybe LaFontaine prevents us from doing that. But would LaFontaine prevent us from reversing this conviction? That is, applying a probable cause standard, for example, or the standard from Rodriguez.
So the Third Department in its decision applies DEVON and finds that there's a founded suspicion that allowed Bracco to first lead the canine around Mr. Butler's car. But because the incidence of the traffic stop had been concluded by that time, he's got his tickets for driving without a license in this case, Rodriguez applies with the reasonable suspicion standard. And to the extent that Rodriguez sort of supersedes DEVON in most circumstances, relying on DEVON in the context of a traffic stop, I believe, is no longer acceptable. I would not say that Rodriguez overrules DEVON, because DEVON may still apply in a context where there's a parked car and there's not a seizure, because of course Rodriguez is a seizure case. But in the context of a traffic stop where the person is seized, as Mr. Butler was, the DEVON standard, I think, has been superseded by the Fourth Amendment jurisprudence in Rodriguez.
And then the second part of my question is, would that, should we choose to do so, allow us to reverse the conviction here on that basis?
It would, Your Honor.
Without offending LaFontaine?
There may be a LaFontaine remittal to determine in the first instance whether the facts, whether there was reasonable suspicion for the search, for the search of the car in that context.
Thank you.
If I may briefly just close, In our brief, we cite extensive history about the racially disparate use of canines to police, and that section is in our probable cause section. But I would like to submit to the court that it is also applicable to the CATS test in determining whether this is a search or not. History is relevant under the CATS test because it informs what society thinks is reasonable and what a reasonable expectation of privacy is. And citizens of New York are affected by this history. They may have had parents who marched in the civil rights era and remember, abuses of dogs in that time. And I think that that means that our expectation of not wanting to be approached by large aggressive dogs like Apache, who is a cross-trained dog to apprehend, bite, and attack suspects, is a reasonable one, and that society would recognize that right as reasonable.
Thank you.
Thank you.